roll call. Johnson, Nicholson, and Burnett are present where he's excused. Approval of the agenda. Motion by Burnett to approve, second by Johnson. Under discussion, here none, all in favor?
Aye.
Nays, motion carried. One item tonight. Actually, two, there's an informational. Okay, first one. Consideration of possible action on a request by Alderman Nicholson to address surface water drainage issues at 1661, 1663 Elkie Lane, held over from August 14th to improve services. Well, the reason why I brought this meeting back to a special meeting, basically I just wanted all the players here. I just want to, it was hard getting everybody together and talk to them. I mean, personally, over the phone, Matt, I talked to you, I talked to Skog. We had a meeting and I requested, you must be Ryan.
Yep.
Okay, I requested three gentlemen to be here at our last meeting and you weren't able to, which is fine. But I just want to get it all out on the table, see what we're up against, what the owner is up against, and what, basically what paths we can take to rectify this. So, Steve, could we go over everything, what we talked about last time? Just for the record.
Well,
The problems we have, why we're here, that memo, and then just want some input from staff.
sure. The block of Irene between Deborah and Elkay Lane, the southern half of that block was vacated in the early 2000s and combined with a couple of other lots to make some buildable lots, a larger number of buildable lots for duplexes, which would face out on the Elkay. As stated in the memo that we provided in the packet for you, there is a memo from July 20th of 2006 from Tom Lesperance, who was the chief building official at the time. Because that pavement on Irene drained to the south, and by vacating this half block of Irene, that would create an impediment to surface water drainage, so a private storm sewer was designed, and it would be the responsibility of the property owner who would be developing those duplexes to both install and maintain that private storm sewer from that point forward. It's my understanding that the original developer then sold the property to a second party. That second party wound up not developing the property either. The property went into receivership, the bank took it, and now the current developers have purchased it from the bank. Now, whether that requirement was dropped, was not properly communicated to subsequent purchasing property owners, we don't know, but the conditions still remain that that would be a private property owner issue to rectify. And to the best of my knowledge, we had a meeting about 2 weeks ago where we discussed this internally with Community and Economic Services staff, and the chief building official has subsequently reached out to the current property owners to let them know, in light of the existence of this memo, that that indeed is the case.
Okay.
So that's where we sit right now.
But, when we had that conversation, Steve, after your meeting, wasn't the two property owners prior to the gentleman that has it now, weren't they supposed to put anything in to take care of the water?
It needed to get put in at some time prior to development of the property. If the building was never put up and it wasn't causing a problem, then I guess that's why something wasn't put in at that time. It wasn't needed until the building actually went up.
Okay.
But again, we would have simply put the requirement out there that it needed to be taken care of, not necessarily when.
Right.
And that's where you start getting into property law, which is an area we don't practice in.
Right.
We try to stay away from the law department if we can, and let them take care of their own stuff. But that falls into disclosure requirements that are supposed to happen with property owners when a property is transferred.
Okay. And then, like inspection, that department, not your department, Department of Public Works, but wasn't it inspection department? Weren't they supposed to put the orders in for the new owners, the prior to put it in?
That I
mean-
can't answer.
That's why I wanted Pete here. Can you, I mean, what are the procedures on that? When someone buys a piece of property, aren't they supposed to be connecting? Pete?
Connecting to what?
Well, the issue we have right here, what do you call it, Steve? I mean, I'm not an engineer.
The private storm sewer?
Right, is that
Okay.
what we're discussing, the,
Right, I'm not sure, I'm truthfully not sure, I don't put the building permits together when they come in, so, I'm not sure how far they dig to get that information out. It sounds
who's in
like-
charge of that, Pete, through inspection? I thought you had something to do with that.
Well, I guess the person who puts it all together would be either Pete O'Connor, or Chad Rothmeyer.
Okay. And then do they give you the orders, or do they give someone like Meaves the orders to follow through, or, I mean,
This has never, truthfully, as far as I know, this has never come up before, something like this. So I'm not sure what the right procedures are. I don't
Okay.
ever know of it.
Kevin, do you know?
Yeah, I mean, one of the things, I mean, we try, internally, we have a property management system called Eclipse, and basically, right, keeps track of all the parcels in our community, and then building permits, inspections, complaints, everything is listed in there. This might have been during the turnover, we had an old system called Paradox, and it might have been in the older system. But generally, when they go through and you know, Pete is correct, you know, we'll go through and look at the Eclipse notes and make sure that if there's anything outstanding that needs to be done, we'll inform the current applicant, whoever's pulling that permit, that something needs to get completed right before we'll issue the permit or before we'll issue the certificate of occupancy. But if there was nothing in the file, then there would be nothing that would require of the person taking that permit out.
Okay. Alderman Johnson or Burnett, do you have any quick? Alderman Johnson?
So when we put forward an order like this, does this get recorded anywhere? I mean, so that when there is a transfer of property, I mean, is this something that a title company would uncover?
So generally, the city doesn't record items unless it's something of our doing, right? If we need an easement or, you know, retain a piece of right-of-way or something like that, we'll record something with the Register of Deeds. But if it's a private property owner, I mean, it's really up to that individual to record something. If they don't record it, there's no really way of tracking it. I think, like I said, through our system, the Eclipse system, you know, we'll keep notes of things that have to go on, but unless it's a specific requirement, you know, involving really just kind of property, actual land or easement, you know, we won't record that. You know, we don't record, I guess, notes or actions like that with the Register of Deeds. It's actually a property action. So unless the prior owner did that and actually recorded something, then no, there would not be a record of it.
Okay, so in which case then, the presumption would be that the title company would never have uncovered this.
Correct. I mean, I can assume that. I mean, sometimes we get a call from a title company, sometimes we get a request for a zoning letter, or sometimes a bank. You know, we'll check in terms of, you know, do we have anything in the system outstanding? But really, in terms of like official records, those would be Register of Deeds at the county, or from a financial perspective, any outstanding assessments would be with the clerk's office. Those are really the two only official legal records. I would consider our Eclipse system is not a legal record per se in terms of checking with that. I mean, it's more just internal notes of, okay, here's things that are going on, but in order to make it binding, it would have to then be recorded in one of those spots.
Okay, so the current developer of this site acquired the property from the bank, is that correct?
Our understanding.
That's our
Okay,
understanding.
and so the bank took it back from the prior developer who defaulted on it?
Again, that's what we understand. We
Okay.
don't know that for sure.
And the reason I bring that up is because if somebody defaulted, I can see where they wouldn't have provided a disclosure, right? That It's just, usually that's the last thing on their mind, which means the bank isn't gonna know about it, so the bank isn't gonna provide a disclosure to the current owner. So here we sit.
Okay, so bottom line, Kevin, when someone buys a piece of property and there needs to be, or Matt, or
A private storm sewer system or.
that, okay, thank you. I mean, who, does inspection have the responsibility to tell the owner that he has to do it or not? I guess that's bottom line, what we gotta find out. I mean, I don't know, with that memo, kind of puts a boomerang into everything, doesn't it? So I guess, I mean, how do we answer that question?
Yeah, I think one of the things that we.
Are we responsible to tell the property owner they gotta hook up? Or isn't it?
Well, in this particular case, it is causing property damage for the resident on the existing Irene Street off of Deborah. Because this duplex is blocking the natural drainage way, they are now impeding the water drainage, which is against Wisconsin drainage law. And that's why the requirement was put on the development back in 2004.
Okay.
And reiterated in 2006,
Okay,
that a private storm sewer must be installed.
okay.
So,
Then I'm asking you, Kevin, I mean, you're director of the inspection department, correct?
Correct.
Does the city have to instruct a property owner on that ordeal? Pete, do you know?
I'm not sure. I'm sorry, I'm not sure.
Okay.
Yeah,
I guess I would have to have that answered.
right, and I think as Director Grenier had stated, we're at a line here of, we have a street right where there's a natural sheet flow down Irene that had been occurring for quite some time. There was development on a site, in order, I guess, for to Matt, I mean, to have a full-blown study in terms of how that diverted or changed the overland sheet flow that was coming off that street. In terms of what was required of that property owner, it's not answering your question, but it is a little bit cloudy because the responsibility of what is coming off our city right away versus what is coming from the private property owner. As Director Grenier mentioned, we don't get involved in private property battles between two adjacent owners. And so in that case, no, it would not be our responsibility to direct a developer to do something. But if it's being caused in terms of something by us, then we would. And I don't think it's quite clear in terms of where that responsibility lies.
Okay. I guess my understanding, I mean, through that memo, that the inspection department was supposed to notify the property owners that they have to hook up.
well, the memo basically did notify, or was clarifying that inspection was ordering the current developer to install that storm sewer system at the time of improvements. So
Okay.
as they built, they would install that storm sewer system. This was the second landowner, is my understanding. That developer, again, ceased to exist. I don't know if there was a third one and then the bank or however. So obviously, like you had stated, from the time the memo was written to when the bank reacquired the property, that information got lost. Who then is responsible to notify the next owner? Yes,
Yes, what, Matt?
that's the question.
Yeah.
And that is, like you said, primarily what we're doing here is,
Right, I just want to know if the city's responsible or not, your inspection department,
Right.
if they were supposed to notify.
Sure.
If you can elaborate, yep.
Yeah, in terms of clarifying, I mean, just based on the timing of when this was done, I mean, obviously this was before my time when some of this happened. And I think that's one of the reasons for the Eclipse system that we built, is in order to catch these things, that when we're going through it, okay, is
Right.
there anything outstanding that we're catching these now? I can't speak to the system at the time in terms of whether that was a miss on us, but I think the whole fact of the foreclosure process, you know, there, have these properties then where, right, as Alderman Johnson said, I mean, stuff doesn't get disclosed or get recorded, and if they didn't record it with us, or we didn't have a system in place at that time, then yes, there's potential that it could have gotten missed.
Okay. Anybody else have any question? Johnson?
It just seems to me there are two things going on right now. And one is a discussion about process improvement, taking a look at obviously what is a unique scenario here. And somewhere it got missed. And so that would be just maybe my challenge back to staff, is to have that discussion to come up with a solution of how we ensure that when property transfers like this happen in the future, that we can ensure that either the new property owner is notified, it's recorded. If Eclipse is already that solution, that's fine. But I think that's one piece of this. And the other piece then is looking at what the current situation is. And I think at least, and I don't want to put words in your mouth, Alderman Nicholson, but what's the solution here? And I mean, it sounds to me like the property owner is being required to hook up now, an expense that they weren't expecting. And so I think what we're trying to figure out is how to resolve that or reconcile that. Is that correct?
That is correct.
From staff's perspective, this is very analogous to situations where sidewalk was ordered, installed as part of the plat, but was never installed. And then at some point down the line, it's been discovered that the sidewalk was indeed necessary, was never installed, so it was ordered, installed after the fact. By that time, we oftentimes have a change in ownership from a builder or developer to a private property owner. As a matter of fact, we had several of these just a few years ago that were discovered. And what you're looking at is simply a matter of timing. The argument could definitely be made that with this particular property owner, the price of the parcel would have been more expensive if the improvements had been made prior, if that drainage system had been installed back in 2006. So the property owner arguably picked that piece of property up at a lower cost because those improvements weren't installed, but are still necessary and they're needing to be installed now. Alternatively, they could have been installed previously and you would have paid a higher price for the property, but they would have been in. Doesn't change the fact that they're still necessary and they're still an expense that would have been borne in some fashion by this new property owner.
Well, it's true, Steve, but if this would have been taken care of 15 years ago roughly, and I'm just ballpark,
Yep,
the improvements would be less than what it is today.
absolutely.
And yeah, I mean, I think that there's a price difference. But yeah, I mean, basically, it's true.
That's why I
You
said
know, when you
part-
buy it, when it's there, it's gonna be more, but what was the price if he would have bought it, if it was hooked up?
No, I understand.
So, I mean, how do you determine that? Well, I just wanna know if the city's on the hook for this, that's all. You know, I guess that's the question. Are they or aren't they? How do we determine that? That's why I'm asking the question.
From, and again, I can't practice in law's area. I can offer a layman's interpretation. But from a legal perspective, I don't think the city had a legal obligation to do this. This really is a private property matter. So is there a obligation or a responsibility on behalf of the city? I would have to state that I don't think so.
Okay. Well, Kevin couldn't answer that.
Yeah, I'm just
So-
digging into the.
Okay.
I wanted to dig into Eclipse files just to get as
Okay.
Dr. Kinnear said, a little better aspect on timing. And I think in terms of where this comes in timing of disclosures, I mean, there's a responsibility on a property owner to do their due diligence before they acquire a piece of
Absolutely.
property. And as I mentioned, I mean, there's legal sources for finding that through title company, register of deeds, or through generally our assessors or our clerk's office, right, that would have any special assessments on there. But in terms of additional things, there's no responsibility for the city to provide any of that documentation about those issues. And so, I mean, it's incumbent upon whoever is acquiring the property to be doing that due diligence of that. And as, you know, Director Greer mentioned in terms of like the timing, I think the sidewalks is a very good example of things are supposed to happen, they don't happen, but they still are there. And it just sometimes is a matter of timing in terms of when it comes.
But let me interrupt, they were ordered, sidewalks were ordered by the city. Right here, it wasn't until third person bought it, or fourth person. Wasn't it two, then the bank? Or was the bank part of it?
We just-
Whatever.
Somewhat
There was
like-
prior people or prior parties that were never ordered. So I don't know if that, does that make a difference with the sidewalks? They were ordered, it skipped the prior property owners, and then they found out, but the city did their job to order them in. This wasn't ordered in until, I don't even know if it's ordered in right now. So, I mean, in the past, last 15 years, it was not ordered in. So, but maybe we should have another discussion on this at our next meeting, which is in what, 2 weeks, Steve?
Well, actually, the
Next week?
The scheduled meeting is next week,
Okay.
and I will tell you.
And I know you had it on the agenda, I didn't know that. I thought we
Yeah.
could clear it up, and so we wouldn't have to,
And I won't be part of that discussion next week. I'm actually going to be in Seattle. So,
okay. Will Matt be there then, or?
Jim will definitely be
Jim?
here.
Okay, okay. All right, well, unless someone else has another, Alderman Burnett or Johnson, do you got any,
Well, I would just maybe
you got any
add
other
that,
questions, or?
I mean, I don't think it would be a reasonable expectation for the current property owner to know that this memo existed. And I think that's, again, where the discrepancy comes into place. And I get what you're saying, Alder Nicholson, that it puts a boomerang into it, but I'm not so sure that it does, in the sense that I don't think the property owner ever would have known that this order existed, because it's not recorded, it's not communicated, meaning it doesn't follow from owner to owner. So there's no reason that they would know that they have to put this in. So the question goes back to process again, and at what point are they told that this has to be done in order for that lot to be buildable? And I'm not sure that I'm still clear on the answer to that, other than we don't have to tell them. I mean, is that correct?
That's what I heard.
Well, I don't want to put it, we do, but I guess I should say our department really isn't ever contacted in terms of a land transaction unless a specific individual comes to us. Like, we're not, when a title company does a search for what's going on, they don't, I mean, some may, but we're not part of a standard part of title diligence. I mean, they don't call and you know, ask to look at our Eclipse system. An individual who's really digging in may go in and say, look, I'm buying this foreclosed property, I know it had a bunch of inspection orders on it, like, tell me what they are and tell me what the cost is, or, you know, or not tell me the cost, but tell me all the outstanding orders, so, right, I can negotiate my price, because this thing needs a lot of work, and then I get a full sense of what that is. But unless somebody individually comes to us, we don't otherwise provide that information.
So you can understand where I'm coming at from this, though, Kevin, which is, how would this property owner ever know that this existed if this wasn't recorded? In which case, then I would kick back the question is, do these types of orders need to be recorded? Because otherwise, this problem could potentially arise again in the future.
Correct. The way, and I guess maybe it's akin to sidewalks or other things, if something doesn't get done and we order it in done and actually do the work, then it gets put on the assessment, right, as a special charge to say, look, we did it. And
Right, but
here's-
this wasn't ordered in.
Correct. It
So
was not.
I see a little difference, but go ahead, Burnett.
Through Alderman Johnson. If I
Oh,
can-
I'm sorry.
I
You're done.
I think, to kind of wrap this up, if I can make a motion to ask Director Vonk and Director Grenier to consult with the city attorney for an opinion, and then refer to the next week's meeting. And one thing I would recommend is perhaps direction of the city attorney, see if this should be a closed session item. I don't know, from the city's liability perspective, I don't know if we should carry this in open, I mean, just a thought. So
Well, we
you'd
can
to
have it
ask-
on the agenda, we can use it or not.
Yeah, just,
Closed-
again, with
closed
the
session.
prerogative of the city
Okay.
attorney, I mean, it would be nice to have that option.
Motion by Burnett, second by Johnson, under discussion. Hearing none, all in favor?
Aye.
Nays, motion carried.
Move to adjourn?
Motion to adjourn
Second.
by Johnson, second by Burnett. All in favor?
Aye.
Nays, motion carried, we're adjourned.